I'm going to go ahead and call the court into session. We are here today for the people versus Kyle Pred. Today is Monday, January 12th, 2026, and I am Judge Angela Adams. So first off, for the charges in this case, Defendant Pred, would you like to enter through your attorneys a blanket plea, or would we like to go through charge by charge?
Your Honor, the people would like to drop one charge.
Okay. What charge would the people like to drop?
That would be the felony medical. Let me get the exact. It's the felony medical charge. After further discussion and confirmation from the victim, we do not believe that this, while it does have probable cause, we don't believe this is necessary for the discussion in court and would like to drop that charge.
Okay. Felony obstruction of medical care
I'm the
is
victim.
removed from the charges.
Thank you, Your Honor.
Actually, before we get to the defendants, please, on all of these charges, I'm going to give the final warning for everyone here. Contempt today is going to be for each charge 10 months, $50,000. If you want to avoid contempt, I should not hear you from this bench unless you are one of the attorneys or the witness next to me. Additionally, ringers on phones should be muted, as should dispatch, please, if you have that.
Am I able to ask a question, boys? Ask her if we can drop it from 50 to like 20. I'm not trying to go fucking broke today.
Sir, you must be delirious on the ground. You know what I mean, sir?
Emergency.
You're delirious, sir.
Okay. We are hearing a lot of people from out in the hallway still, very loudly.
Yeah. I'm gonna pull some of y'all. Ventura, you might need to get into the helicopter.
Hey, can you guys shut up? You're
Oh,
so
Jesus
loud.
Christ.
You're
All right.
so loud.
So, for these charges, would the defendant like to enter a blanket plea, or would we like to go charge by charge?
I would. The boys tell her I'd like to go charge by charge.
Charge by charge, please, Your Honor.
All right. So, for the charge of battery of a government employee, how do you play?
That was just dropped.
No, it's all left.
Not guilty, Your Honor.
For the charge of criminal threats,
Not guilty.
for the charge of unlawful imprisonment,
Not guilty.
for the charge of extortion,
Not guilty.
for the charge of felony trespassing,
Not guilty.
for the charge of corruption,
Not guilty.
and for the charge of felony authority, felony offenses.
Not guilty.
God damn, it's a lot of fucking charges from these people. What's going on here?
All right. So with that, if we don't have any further pretrial motions to attend to, Marshal Sparks, if you would like to begin with your opening statement, please.
Thank you, Your Honor. Your Honor, counselors, and good people of the court, this is not a complicated case. This is not a philosophical debate about government employees, their attorneys. This is not political assassination. This isn't about how someone, and I quote, Your Honor, from a docket post, is an asshole, and I quote. It's about an abuse of authority, abuse of power, and a targeted act against one of our first responders, just attempting to do their job. Just attempting to be a good person, to care for those who need that care. On or around the 2nd of January 2026, Mr. Jimmy Bowler, an EMT with the San Andreas Medical Group's Emergency Medical Services team, was just doing his job. He was attempting to take care of patients, to keep people alive, to do good things for people who deserve to take another breath. But unfortunately, Your Honor, his own breath was taken from him. You'll see with the facts and circumstances, along with previous depositions, that put the defendant Kyle Pred alone with EMT Bowler in the ICU lobby at the Crusade Medical Center. You will hear direct testimony that shows the violent actions performed by Mr. Pred in that same lobby. You will hear from the victim himself. Mr. Jimmy Bowler will take the stand and give his direct testimony and go over the horrific experiences that transpired against him. You will then hear from Dr. Watson, Dr. Perry Watson, one of the most esteemed members and doctors as an expert within the San Andreas Medical Group. She'll go over the findings on the injuries sustained by Mr. Bowler. The timeline of events will be clear. The actions will be clear. Your Honor, at the end of this trial, the question is not one regarding Mr. Pred and his rights. It's not one of defamation or falsified rumors. The question will be before you, Your Honor, whether the evidence proves he has crossed the line from authority to coercion, from an officer to an offender, and whether this court will show that those lines, that boundary, must be drawn. Because if this is normalized, Your Honor, if this is the standard as to how we treat our medics, we don't get law. We get rank. We get an abuse of authority. And that, Your Honor, is not justice. That is intimidation, paperwork, and foot stomping when that intimidation doesn't go their way. Thank you.
All right. Defense, if you would like to make your opening.
Yes, Your Honor. Your Honor, people of the court, today we are tasked with the defense of a citizen of San Andreas who faces accusations from another citizen of San Andreas. And that's it. It's an accusation. My client, Kyle Pred, is foundationally innocent until proven guilty. Proven guilty beyond all reasonable doubt. For each of the now 7 charges he is facing today, the prosecution must prove those charges beyond all reasonable doubt. The evidence, of course, must then not just be convincing, but almost unassailable. We should be expecting to hear from the prosecution from multiple first-party direct witnesses. We should be expecting to hear about forensic evidence, primary evidence that proves the accusations levied against Mr. Pred. The prosecution should be bringing this evidence forward to prove that this man did what he is accused of. Instead, spoiler alert, what you're going to hear today are accusations. And we'll also get a smattering of circumstantial evidence. There'll be inferences and innuendo. There won't be any definitive evidence from this prosecution. There are 3 primary charges that, if not proven, the rest of the house of cards will fall with them. Battery of a government employee, criminal threats, unlawful imprisonment. These are the physical acts Mr. Pred is being accused of. The rest of the charges rest upon the foundation of these alleged actions. The defense will highlight every doubt from these allegations. We will highlight the missing evidence. We will highlight the investigatorial missteps, the obvious confirmation bias from this prosecution. We do not need to prove Kyle Pred's innocence. Only leave reasonable doubt for Your Honor to find our client not guilty. And to set the standard once again, that a prosecution must be built upon a good faith investigation, based upon evidence that proves guilt beyond any reasonable doubt, not an alleged victim's claim, and then some facetious commentary after the fact. Emotive language and pretending to almost cry because it's tragic that something almost might have maybe sort of happened we accusing Kyle Pred of won't cut it in a logical assessment of the evidence that will not be provided here today by the prosecution. The stakes of this have been lost along the way. Mr. Pred is facing not only criminal conviction, he is facing 2,000 times the time and fine he should face legislatively. He is also facing a punitive injunction that, in fact, restricts his freedoms worse than a hag-level conviction would. He could literally murder someone today, be convicted of that murder, and expunged and rehired into the LSPD quicker than this injunction would end.
EMS, choke themselves.
Fred,
Fred,
good.
There
good
will be
muscle
order in
man.
this court, or you will be
Choke
issued contempt. Contempt is currently 10
He's got a
minutes
gas
or
can in
10
his
months
hands.
and $50,000 per charge. This is the last
good.
warning for
good.
everyone.
Fred, good, Marshall
Yeah,
Fred.
choke
EMS,
themselves.
choke themselves. Fred, good, Marshall Fred. EMS, choke
So that's
themselves.
one count of contempt for
Fred,
Reed. Is
Fred.
anyone else
Are we
looking for a
stopping?
count of contempt?
All right.
All right.
You know who you are. You owe me 100K.
Dip, boys, dip.
All right.
Your Honor,
Sorry
step
about
ready
that,
when you are.
Grayson. If you could please continue.
Run,
Bomb
Reed,
in
run.
this courtroom.
Yeah.
There's a bomb in the courtroom.
They're yelling bomb.
Okay. I'll repeat the last sentence. Kyle Pred could murder somebody today, be convicted of it in a month, and expunged and rehired into the LSPD quicker than this injunction that is being requested would end. Such stakes are high, and thus the burden on the prosecution should be high. Emotive language about a victim does not cut it. The accusation itself does not cut it. Legislatively, my client is innocent until proven guilty. The prosecution asked for these consequences. So it's no more trust me, bro. Now it's time to prove it, bro. So prove it.
All right. Prosecution, if you would like to call your first witness.
Yes, Your Honor, we're going to be calling EMT Jimmy Bowler to the stand.
Now, Mr. Bowler, before you get on the stand, would you mind please raising your left hand in the air? Do you swear to tell the truth, the whole truth, and nothing but the truth under the penalty of perjury? So help you, Nikita.
I swear.
The witness has been sworn in, Your Honor.
Thank you.
Does the DOC guard have a thug chain on?
Kind of hard.
I think it's a Kev Von chain.
Oh.
Prosecutor Sparks, once you're ready.
Ready when you are, Your Honor.
Free to begin.
Perfect. Mr. Bowler, I will remind you that as someone on the witness stand, just for the sanctity of the court record, at any point in time, you need a break, you need recess, you need to contain whatever it is that you're containing. As the alleged victim in these charges, please just speak to the judge. Do you understand?
Yes, I understand.
Could you state your name just for the record?
Jimmy Bowler.
And what is your profession?
I am an EMT
Where do you work?
at CMC Hospital.
And were you on duty on January 2nd, 2026?
Yes, I was.
Was there anything eventful that happened during that day?
Yes, there was something.
What was that thing?
I was just doing my duty and I got attacked by someone who then screamed, "I'm Kai Brad."
Well, let's take a step back there. With reference to the People's A, the incident in question, it states that you were attending to a injured officer. Do you recall this?
Yes,
Do you remember who that was?
it was the officer Breakaway.
Understood. And what happened after you treated him?
So I treated him around MRPD and then transported him to CMC, where I loaded him off and brought him to Dr. Snow in the lobby.
Which lobby?
The CMC lobby, where Dr. Snow is checking in every person.
Gotcha. So the main lobby, just for clarity of the court?
Yes.
Okay. And what proceeded after that?
While I was checking in breakaway, someone asked me if I could help them to get into the ICU to visit the person, and I told them that I needed a few minutes to check on breakaway after checking him in.
At this point in time, did you recognize this individual?
No. I had no clue who he was.
Do you recall what they were wearing?
They were wearing a jacket, I think a blue one, a tie, a white shirt, and just normal black pants.
Okay, so standard civilian clothing.
Yes.
Okay. What did you do after you told them that you need to step away?
I went into the ER to check on breakaway if he would get up or if Dr. Snow would need further assistance with him.
Okay.
But breakaway got on their feet then again.
Okay. And what did you do following that?
I went back into the main lobby where the person was still waiting for me.
It was the same exact person, correct?
Yes, that was the exact same person.
Okay. And what did you do next?
We walked slowly towards the doors for the ICU lobby, and I tried to ask who he was and who he wanted to visit, as it's common procedure for us to ask before we open the doors who he wants to visit to make sure they are on the emergency list, or if we can validate with the person inside the ICU if they want to have visitations.
Did he provide any information concerning his identity?
No, he did not.
Did he state who he was visiting?
No.
Were you able to
The only
speak to? Bear with me, Mr. Bowler. Were you able to speak to any ICU patients to confirm that this was that this person was to be seen?
No.
Okay. So you stated that you had requested information from him. What happened after that?
It seems like at some point when we went behind the doors, he kind of snapped them and screamed, grabbed my hand, and started choking me.
Let's take a step back. Which doors were you entering?
The ones into the ICU lobby.
So you didn't
right
enter the
before
ICU at this.
doors.
Right. So
No.
you weren't inside the ICU at this time.
No, I wasn't.
Objection.
Is-
Counsel is testifying.
Rebuttal.
Yes, Your Honor. I'm not providing specific testimony. I'm asking for clarity concerning the situation and nature of the events. Where this transpired, how it transpired, and what was happening is simply a clarifying question. I'm not providing any new evidence, Your Honor.
Then, Your Honor, she should ask clarifying questions and not provide the witness with the answer she's seeking.
All right. So I'm going to overrule the objection at this time, but let's have the questions be a bit more clearest questions. Additionally, I'm going to go ahead and warn for those of you who may have just entered, I should not be able to hear you behind this bench. If I hear you, you will get contempt.
My bad, Your Honor. That's on me. My bad. My bad, dog.
All right. Please continue, Marshal Sparks.
Sure. Some of these questions may sound repetitive, Your Honor. That's not the intention. It's just to get us back on track with the timeline. Mr. Bowler, just to clarify, you stated you went through the doors. What doors were they?
It were the ICU lobby doors, so we were right in front of the normal ICU doors then.
Are those doors publicly accessible?
Can you clarify?
If I were, well, let me take a step back. Does it require like special access to get into that lobby?
No, it does not.
Understood. When you entered into the ICU lobby, who was there?
It was the person and just me.
So just for clarity of the court, there was no other person except for you and the other individual in that room.
Exactly.
Okay. You stated that they became aggressive. What happened when they became aggressive?
He grabbed my
Objection,
hand.
leading.
Any rebuttal?
Yes, Your Honor. I am not asking a leading question. I'm asked an open-ended question. I said, what happened after they did this? I'm not leading to a specific answer. I'm not implying a specific answer. Mr. Bowler could state anywhere between he was taken by aliens and teleported to Timbuktu, or that he turned into a lion, or that he walked away singing Mary Poppins. It's an open-ended question, Your Honor. It's standard direct examination.
Can I add more, Your Honor?
Certainly.
Okay, she's containing the answer. She's once again asking, hey, you said he was aggressive. What happened when he was aggressive? The aggressive is prejudicial. She is adding it and thus feeding the answer directly to the witness to continue in that vein. It's prejudicial, Your Honor.
Your Honor, may I rebut?
So I'm going to overrule the objection at this point because she was simply repeating part of his previous answer to continue the timeline into this question. If you could please continue your questions, Marshal Sparks.
Yeah, just one moment, Your Honor. Understood. Mr. Bullard, do you need me to rephrase the question or restate the question?
Can you restate it?
Sure. Per your previous testimony, you stated that this individual became aggressive. What happened after he became aggressive?
He grabbed my hand, yelled at me he is the chief of police, Kyle Brad, and went behind me and started choking me and started
Okay.
threatening my life.
Well, let's take a step back. You stated that he was chief of police Kyle Pred. Is that correct?
Yes.
Did he present to any badge at this time?
No.
Did he have any identifying markers of a law enforcement officer?
Not that I could see.
Was there any way at all, for any reason, you were able to identify this man as a law enforcement officer or Kyle Pred?
No.
Okay. You stated that he grabbed your hand. Is that correct?
Yes.
And then he choked you?
He grabbed my hand, so I lost my balance so he could get behind me and start choking me.
How did you feel?
I felt scared. I was fearing for my life.
I'm sorry to hear that. You say he threatened you in your own testimony. What was that threat?
He said if I would not let him in, he would stab my neck and would end my life.
How did that make you feel?
I was really threatened and scared for my life.
I'm very sorry. So what did you do?
It's the only thing I could do at that moment, and it was his request to open the ICU doors, so he would let loose of me.
So just for clarity of the court, because you were scared of your life, you complied with his request?
Yes.
Is there any other reason that you would have complied with his request?
Only if he would have provided who he was and also told me who he wants to visit.
But he didn't, did he?
He did not.
How long did he hold you there?
For like 10 seconds, I started to lose my air.
It's okay. Take your time. Are you good for me to continue?
Yeah.
Okay. So he held you for 10 seconds. What did he do after he let you go?
I tried to gain a bit of distance from the ICU doors and called 78 or that I'm emergency, that I need backup.
So what does a 78's call?
78 call means for us that we need emergency backup.
And why did you call that?
Because my life was in danger at that point. I was not sure if he would come back and maybe do it. Or maybe what he's gonna do in the ICU.
And why did you think that?
Because because he was aggressive to me and threatened me to stab my neck.
Your Honor, can we put an image on the board, please?
I have the image sent for preview first, please.
It's the 311 in the People's A. It's evidence 3. I'm sorry.
That can be put up, yes, ma'am.
Thank you very much. Please let me know if you need me to send it to you otherwise, Your Honor. Thank you. Mr. Bowler, is that the 311 that you sent?
Yes, it is the 311 I sent.
And what did you do after you sent that 311?
I waited for the law enforcement to arrive at the hospital.
And what were you feeling at that time?
I was feeling a bit lightheaded at that point because of the oxygen starving, but also still scared a lot.
I'm very sorry. What did you do after that?
When law enforcement arrived, I let them into the ICU.
And then?
And then I waited. And then Dr. Perry came.
From your best recollection, do you recall how long that took?
Like a few minutes.
So you saw Dr. Watson nearly immediately after the assault.
Yes.
And what transpired when you met with Dr. Watson?
She told me to lie down in a bed for now, because she needed to check on someone else.
Okay. And what did she do when she came back?
She examined the injuries. And also gave me an O2 mask so I could get some oxygen back into my system.
And what were those injuries? Do you recall?
I had for a long time choke marks around my neck. And I think my eyes were also a bit reddish. At least that's how it looked in the reflections.
But you were in extreme pain, right?
Yes. And out of breath too.
Are you still in recovery?
No. So far everything went away and I can be on duty again.
How long did it take for you to recover?
Until everything went away, it took like 5 days.
So it took you 5 days to recover from the battery of Chief of Police?
Yes.
Were you able to work during that time?
Yes, I was able to work after a few days.
So after the battery, you were able to work?
Right after the battery, I took some time off to recollect my thoughts, etc.
Why'd you take the time off outside of the pain?
Because I was a bit scared about my life, nervous around officers.
Because of the actions that were taken that day?
Yes.
Bear with me just one moment, Your Honor. No further questions on direct, Your Honor.
All right. Defense? Cross?
Can we get 2 minutes to gather our thoughts?
Absolutely.
Okay.
Hey, I'm great.
Oh, he's been so stressed out, so he's running straight to the personal assistant?
Getting out of the hospital. Sorry, I'm late.
All right. So for everyone who may have just entered the courtroom, please make sure you are whispering. I should not be hearing you behind the bench. All right. Defense, are we ready to move forward?
Grabs Bobby's mustache and yanks
I'm making.
it.
I'm making.
Hey, Mr. Bowler, how's it going?
It's all right.
Okay, so I just want to go through a couple things in your testimony, right? You said you were choked. Was this an extreme choking?
I was losing my air, so yes.
Okay, but you're able to gauge 10 seconds while getting choked.
It's a rough estimation.
Right, even though you were oxygen deprived at that point, as you claim?
Your Honor, objection, opinion of a layperson. He's providing his own analysis of the situation, and these are questions for more of an expert witness.
I would only just, I mean, it's something that he claimed, and not only that, Your Honor, I mean, at that point, if he's saying he's oxygen deprived, then he's a layperson, you know, he's EMS. I guess he's not really oxygen deprived then with that logic. I'm just assessing basically what he was feeling at the time because I'm trying to gauge how extreme this chokehold was.
Yeah, I will also note that the prosecution was allowed to ask multiple questions pertaining to his injuries. If he can testify as to his injuries then, he can testify as to his injuries now.
Otherwise, if he's just a layperson, I guess they're suggesting just strike his testimony altogether.
What?
All right.
That's not how.
So I was going to allow him to continue to answer the question. Was also going to request that the questions be phrased a bit more like questions, though.
Okay.
All right, please continue.
Can you answer it?
Can you repeat your question, please?
If you'd like to take this chance to get it rephrased a bit more like a question.
What was the last thing? I just had a brain fart just now.
Last thing I had noted was right, even though oxygen deprived, and then objections came in.
Okay.
Previous to that was the ability to gauge 10 seconds.
Yeah. So you're still able to gauge 10 seconds even though you're oxygen deprived, correct?
It felt like 10 seconds if you want to go like this.
Okay. And given the violent nature, since you said you were, you know, out of work for 5 days, how violent chokehold was, I just want to clarify. Given how violent the choke was, you were still able to have enough control to unlock the ICU door?
Objection, testifying, objection, misstatement of testimony, objection, foundation, objection, scope.
I don't know where to begin, Your Honor. That's a lot of sweat beads right there. But
so,
Your Honor, can we please have the personal attacks concerning the situation to be to a minimum?
Can we please pick one objection at a time so that we aren't trying to have 4 go back and forth, because that's going to delay this case unnecessarily.
Okay,
What objection would you like to make?
Objection to form.
Right. Any rebuttal?
What the fuck is a objection to form? Your Honor, all I'm basically going through is basically what he said earlier. I was recounting what he said on stand. He said everything was so extreme. He was out of work for 5 days. At this point, like, I'm just trying to gauge the nature of, look, if this was this violent and he's claiming to be able to do all this while getting choked that hard and he has to step out of work, this is the line I'm laying out for him to kind of go through and explore how crazy was this chokehold and how he's able to perform these acts while going through that crazy chokehold. This is basically me just laying the foundation for all of that, Your Honor.
All right. So it is within the scope of what was asked previously.
It's not my objection.
Let's keep this moving along, please. Mr. Bowler, you can answer the question. Do you need it to be repeated for you?
Can you repeat it, please?
Tony, would you like to repeat, or would you like me to
What's on the
phrase
record,
the
Your
essence
Honor?
of it?
Yeah.
So what I've got on the record is, given the violent nature, you being out of work for 5 days, how did you still have the control to unlock the ICU doors?
Okay, I needed to recover for 5 days, or better said, the marks were visible for 5 days that he did to me.
But I'm sorry. So I'm a little confused now. Hold on, give me a second, Your Honor. Let me rephrase what I want to ask a little bit more. I'm just gonna move forward and I would circle back to that question I want to ask, okay? Okay, Your Honor. I'm just gonna go and move forward for now. So when it comes to identification of the other person as you claimed it, you said on testimony that, you couldn't identify the person. Even in the People's A, there's a recording in there with you, stating that, oh, where was it? Let me just pull up the specific timeline so that we can all reference it. Around the 4-minute mark of the interview, the question Sparks asked you was that, and so at no point in time were you able to identify all that he was an officer at all, that he was an officer or any sort of government official. You said yes, exactly. Is that correct?
Yes.
And then you said, and the next question to you in the interview was, okay, you didn't recognize him at all for any other reason. You didn't recognize him as Kyle Pred, correct?
Correct.
And then you said it was the first time I was meeting this person.
Yes.
And according to the image up there, you stated this was an emergency, so you called 78s, but you were using the 311 system?
Your Honor, objection badgering.
Your Honor, I'm just asking what I'm just asking and confirming what his actions are. I haven't badgered or argued with him at any point. I'm sticking to what was given in evidence. I'm just confirming that those answers that he has on record and also in testimony today is still the same and also factual. That's all I'm asking, Your Honor. I haven't argued with him yet.
I'm going to overrule on the badgering. Let's keep this moving along. Jimmy, the question was asking why you called for 78s over 311.
Yeah.
I did it once.
Oh, go ahead. Oh, sorry. I mean, he did it once.
All right. I did it over 311 because on the radio was a lot of chatter and also to get attention to it too. So it's common use that we do it as on radio and also as a 311.
Huh. So despite the fact that you also said that you couldn't identify the person in testimony and on recording, why do you say it was Kyle Pred in the emergency then?
Because he stated to me he was Kyle Pred, so I could go from there.
So wait, so was that you can identify or you can't then?
I was not able to identify them, but he stated he was Kyle Pred.
Okay, just with that logic, if I said it was Benji Ramos, am I Benji Ramos?
Your Honor, objection, relevance.
Your Honor, it was in his own testimony, his own logic, that he said that this person's name was Kyle Pred, therefore he is. I'm just testing it and see if that logic is consistent. That's all, Your Honor.
It's also extrapolation of fact, Your Honor. He might not know who Benji Ramos is.
Your Honor, neither did he said the same thing. He didn't know who this person was, but said it was Kyle Pred anyway. Same logic, same circumstances.
I will allow the witness to answer this question, but let's get back to the facts at hand at the case after this, please.
Oh yeah, Your Honor. I'm like I said, I'm just I'm just going based
So,
on what this was saying.
Jimmy, the question counselor asked was that if he said his name was Benji Ramos, is he Benji Ramos if you don't know otherwise?
No, but I would still relay that name in distress.
Okay. Or you said no?
Huh?
Did you say no as the first thing?
I said I would still relay the name because I'm in distress.
But I'm sorry, Your Honor. For the record, he did say no, and then he said all the other stuff, right?
He said no, but he would still relay the name if he was in distress, was the
Okay,
original
okay.
answer.
Can I just motion to strike everything after no? I think that's satisfactory for the question.
Your Honor,
it's a
I
yes
would.
or no question, Your
I have
Honor.
a response to that motion.
Response, Counselor Sparks.
Yeah, no, the counselor has the ability to interrupt the specific answer. It is also relevant to keep that particular portion on the record as it is definitive as to the answer the question and answer. He asked a general open-ended question. Just because he doesn't like what the witness stated doesn't mean that it's necessary to be stricken.
Your Honor, there's also an issue of understanding, but I did hear no. I couldn't understand the rest. For me, I would just motion just to strike the rest because no is sufficient to answer the question. That's all.
That's why I provided the clarification of what the
Yeah.
rest of that initial statement was said.
So I couldn't interrupt him at the moment if I can understand the rest of it. That's why, Your Honor.
All right. If we have any further answers where you don't understand, make sure to object promptly. At this time, we are going to let the witness's statement, as was stated, stand. If we'd like to move on to the next question, please.
I'm gonna see if my counsel has anything, Your Honor.
Your Honor, at this point, I would like
diff.
to motion to strike the witness as unreliable. There are multiple points through how its testimony here today, and then in the statements in report 38901, and in the interview that he gave that's listed as the EMS victim interrogation, in which his timeline has contradicted itself. Here today, he has stated that Kyle Pred did not identify himself up until the point where he was beyond the doors and actively threatening him and assaulting him. Whereas in the testimony given in the witness statement provided in report 38901, he states initially in the verbal statement taken on scene that he found Kyle Pred. Nothing is stated about when Kyle Pred identified himself in that one, but in the written statement below it, right, after asking multiple times, they stated that they were the chief of police, Kyle Pred, and it was none of my business. This happened before the alleged assault. At this point, this witness has proven himself to be unreliable. His statements are all over the place. He should be stricken from the record. He should face perjury charges for lying under oath. That man does not deserve to be on the record right now. It's disgusting what's occurring here today.
Marshal Sparks, any rebuttal?
Sure, yeah. So first and foremost, Your Honor, I don't need to go over this, but just for the sanctity of the court record, people in the court and attorneys who don't know what striking of a witness is, the burden to strike a witness is extremely high. Even if there are small contradictions in statements, this man was injured. The witness statement was taken at the time of the injury. We have a medical report that corroborates those particular statements. We have an interview that corroborates those direct statements. Just because there's a tiny colon or a tiny comma instead of a period, just because there's tiny mistakes, does not make this witness's testimony unreliable. That burden is extremely high. Furthermore, to imply that a victim of a circumstance, a victim of a battery, is necessarily lying on the stand and requesting perjury charges be placed in of itself, to quote the defense, is bad faith. Once again, they're attacking the character, and they're trying to they're trying, instead of to actual argue that doubt and put that information in the particular closing, they're simply trying to remove everything that the victim has stated. This is a victim statement, Your Honor. The man's nervous, very clearly. He was injured by material fact, by his own statement. There are going to be tiny little details, if you even notice, even if it's there in that particular testimony, but that does not mean a victim's statement should be completely disregarded for the court record. Finally, Your Honor, we understand that you're a living, breathing human being with intelligence, able to discern specific and contradictory information. We understand that you can review this testimony, the statements, and the interview on deliberation. That is something for you to determine, not for a counselor to stand up and object and say disgusting for this. Sorry, Your Honor, I'll take that back. To claim that this man's entire statement needs to be stricken. Thank you.
May I rebut again, Your Honor?
Absolutely.
Your Honor, I am not pointing out tiny, small changes in testimony from one moment to another. I am pointing out foundational changes in what he is saying, in the timeline, a crucial timeline, which puts Mr. Bowler and Kyle Pred alone at a certain point of time, right? At the point where something allegedly occurred. If that timeline is messed up, if the causal chain is broken, then all probable cause for these charges falls apart, right? Mr. Bowler may be attempting to tell the truth. If through whatever injury he sustained, and I'm not arguing he sustained an injury, right? If through that injury his testimony becomes unreliable because of that injury, again it should be stricken from the record. Marshall Sparks is attempting to keep this on the record because it helps her case. In fact, it's foundational for her case. I get it. I understand. I sympathize that what we have found here today is catastrophic for the prosecution. But unfortunately, this is the only proof they have that something happened involving Kyle Pred. And the fact it is so unreliable, this is not reasonable doubt. This is beyond reasonable doubt. This is absolutely foundationally showing that this witness, the only witness, is unreliable. Now, whether that is because they are lying or because they were so injured at the time they cannot be convincing or reliable. Your Honor, this is what it is. These are not small, nitpicky minutiae. Oh, he said and, but he meant but. Or this is a language issue. This is a timeline issue. The timeline issue is clear. In one report, he says he identified himself as Kyle Pred, Chief of Police, before they were alone. In another report, right here today, in court, Mr. Bowler says, that Kyle Pred did not identify himself until they were beyond and they were alone, and Kyle Pred had his hands around his neck and was threatening him. These are foundationally different statements, Your Honor. Please.
Okay.
Is this a closing, Your Honor, or a motion?
For the motion to strike the witness, I'm going to go ahead and overrule it. If there are things about inconsistencies within the statement that you would like to highlight, please do so during your closing or evidence highlighting. Is there any further cross for this witness?
Sure, I've got one. Hello, Mr. Bowler.
Hello.
Why are you lying?
I'm not lying.
When did you lie? Did you lie in your initial statement?
Your Honor, I'm going to object to relevance. I'm going to object to a whole bunch of other stuff here. You know well why I'm objecting to this, Your Honor. This is insane.
Any rebuttal to the objection, Grayson?
Your Honor, it's a fair question. I've highlighted issues with his testimony. I want to question him on those issues to his testimony.
All right. I will allow you to continue questioning the witness, but let's tone down the rhetoric and keep it to the facts with the questions, please.
Okay, Mr. Bowler, there are inconsistencies with your statement. In the statement you gave on the day of, on the 2nd of January, you state something different to what you have stated here today. Is there a reason for that?
I have no clue what you're asking about. What is
Your Honor, objection, vague and ambiguous motion to strike. Very clearly, the witness doesn't understand the question, so we're asking for it to be clarified by counsel.
Your Honor, it's very clear. It's very clear. Okay. It's obvious what I'm talking about. If I have to get pedantic and start reading out...
Officers, please mute your dispatch in this courtroom.
I'll respond.
Do you want me to direct him specifically to the line of what he stated and then specifically to the... I'm willing to do so. To me, it's very clear.
If they want to file AI
to remove any questions about it, let's point specifically to what is being spoken of.
Okay, Mr. Bowler, in report 38901, in your written statement that you gave on the day of this event, right?
Officers, please mute the dispatch or else leave the courtroom. Sorry about that, Grayson. Please continue.
You're okay. Okay. So, in this statement, in report 38901, right, in the written statement from yourself, so this is a statement you wrote, you stated, I returned to the lobby where the individual was still waiting. I asked who they were, and as I had not previously encountered them and who they wished to visit, after asking multiple times, they stated they were the Chief of Police, Kyle Pred. You recognize this statement? This is you, Mr. Bowler?
Yes. Yes, okay. I recognize.
Today, under oath, right? Let me find it.
I don't think so.
I'm looking for it. At this point, the question was, the question was, you stated they became aggressive. What happened after? You stated he grabbed my hand, yelled at me. He was the chief of police, Kyle Pred. He went behind you and choked you. He threatened your life. When was it, Mr. Bowler? When did he identify himself?
Right as he was grabbing my hand. And that is also how my written statement is based on.
Do you need me to read that to you again, Mr. Bowler? Are you
Your Honor,
maintaining
objection
that as fact?
argumentative.
I'm giving him a chance to clarify.
All right, I'm going to overrule the objection. Jimmy, if you'd like to answer the question, please.
If he has the written statement in front of him, then he knows what the next sentence is in it.
Yes, the next statement is he then said, "That's it." That's your next sentence, right? But the problem is,
And grabbed
one
my
happened.
hand.
Mr. Bowler, did it happen before or after you were assaulted? Because these two statements are not the same.
It happened right as it happened.
Okay.
I feel like a language barrier is.
Any further cross?
Nope.
Will this witness be marked for recall?
No, Your Honor, the defense does not want this one.
All right. Any redirect for this witness?
There will be, Your Honor. Bear with me just one moment. Could we take a brief 5-minute recess for the defendant? Sorry, not defendant, for the victim to just clear his head so we can get water, things like that.
We have been going for about an hour now, about 2 hours if you count the pretrial. So let's do a 5-minute recess until 4, and we will reconvene then. This
Your Honor,
allows
sorry,
everyone
go ahead.
to get a restroom break, grab water, do what they may need to do.
I'm gonna go for a walk.
Your Honor, may I provide food and water to a separate third party to provide it to the witness, please?
I've
I have
checked with the witness. He's already been provided
perfect.
food and drink
Perfect.
from EMS.
No worries. That's perfectly fine. Thank you.
Back in session at this time. The people were about to have redirect for this witness. If you would like to please continue, Marshal Sparks.
Mr. Bowler, are you doing okay?
Yes, I'm doing okay.
Okay. Are you good to proceed with questioning?
Yes, I'm good.
Okay. In cross-examination, there was a lot of discussion concerning and the identity of the individual. I just have only one clarifying question. No matter who he identified as, that particular individual, did they have authority to enter the ICU to the best of your knowledge?
No,
Objection.
Thank you.
Improper expert opinion. We want to get that question struck. I was objecting. They continued anyway.
All right. Any rebuttal to the objection?
Yeah, he's not an expert opinion. He's not providing improper expert opinion. He's providing his observations and understanding concerning his actions. It's not the right objection.
Your Honor, knowledge of whether or not Kyle Pred had authority to be there is beyond the scope of Mr. Boyer's knowledge. This is absolutely outside of his expert opinion. He has no opinion on this. It is speculative at best.
At this time, I'm going to overrule the objection, allow the question to stand with just the simple answer of no and
Can you
no
speak
further
up, Your Honor,
elaboration.
please?
I'm currently speaking as loud as I possibly can. Are you not able to hear me throughout the courtroom?
I can just about hear you back here.
I can hear you.
Okay, you may need to move forward a bit to hear better. I'm sorry, I cannot yell any louder than I am.
No worries, thank you.
All right. So if the people have no further questions, Mr. Bowler, thank you so much for your testimony here today. You may step down. You are no longer under oath.
Dr. Watson.
Thank you, Your Honor.
Dr. Watson.
All right. Prosecution, would you like to call your next witness, please?
Yes, Your Honor. We're going to be calling our expert witness, Dr. Perry Watson, to the stand. Is it necessary that we voir dire the witness at this time for expert testimony?
Defense, do you accept this witness as an expert for medical purposes, or do we need to go through her qualifications?
I have no objections to Dr. Perry Watson as an expert witness.
All right. So the witness is entered as an expert witness. If you could please get the witness sworn in.
Dr. Watson, please raise your left hand in the air. Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury, so help you sob?
I do.
This witness has been sworn in, Your Honor.
Thank you. And if you'd like to make yourself comfortable, Dr. Perry, I don't know if you prefer to sit or stand.
I've got to stand. I've got to stand.
All right. Marshall Sparks, the witness is sworn in.
Thank you, Your Honor. Dr. Watson, could you just state your name for the record, please?
Dr. Perry Watson.
And where do you work?
At the San Andreas Medical Group.
And what is your position in that group?
I'm an attending doctor.
And what does that mean to the people of the court, just to let everyone else know?
Doctor Command.
Okay. So we're going to be referencing a medical report in the People's A. Have you had time to review that medical report?
Yes,
Who wrote that medical report?
I did.
When did you write that medical report?
On the 2nd of January.
Who was that medical report written for?
Jimmy Bowler.
And why was that medical report written?
I gotta go.
Dr. Watson, did you hear me? I'm sorry.
No, I did not. What was the last question?
Why was that medical report written?
As the patient had sustained some injuries and requested a medical report be written for it.
And what were just in generalities, we'll get the specifics. In generalities, what were those injuries?
Partial oxygen I can't even say the word. Deprivation. There we go. Signs that he'd been also choked out.
Okay, let's take a step back then. When Mr. Bowler approached you for evaluation, what were your initial observations?
He was just initially he was struggling for a little bit of breath and trying to speak. We just asked him to take a seat because I did not want him falling over or anything like that. His obvious, what's the word I'm looking for? Gasping.
It's okay. Take your time. Why were you afraid of him falling over?
Because when it comes to oxygen and stuff like that, possibilities are possibilities when it comes to that can be like dizziness, nausea, can cause loss in balance.
Okay. You evaluated him, correct?
Mm-hmm.
And what were your specific findings? Take your time.
When I was able to observe him, he had the startings of what looked like a red mark around his neck starting to grow, along with his eyes being slightly red and bloodshot.
Okay. Any other observations when you were evaluating him?
Other than him like struggling to regulate his oxygen back. Other than that, just the red mark around his neck and the eyes, and obvious lack of oxygen.
Okay. And what was your treatment plan?
His treatment plan was to lay in bed for a little bit, to get his oxygen back to a nice place where he wasn't going to be dizzy and wouldn't fall over or hurt himself any further, along with a O2 mask to help regulate his breathing a little bit better.
Okay. How long were you with the patient?
Apologies, could you repeat that?
Yes, absolutely. How long were you with the patient?
Okay.
To like check him up, like how long I was with him?
Yeah. Yeah. How long were you with
Um,
him for the evaluation in the medical report?
Maybe 5-10 minutes.
Okay. Just referencing my notes, Your Honor. Just bear with me. And beyond what you've stated concerning your evaluation report thus far, what was your conclusion in your findings?
That he had partial I can't even say the word now. Oxygen deprivation, and that he had been that he had been out per se, like something had caused him to stop, his body to stop.
Understood. Okay.
Words.
You're fine. It's on court record, and we can reference the medical report. It's not an issue. That being said, I'm only going to ask one. I'm only going to ask one question. I'm not going to discuss any further. At any point in time, based on your medical analysis, evaluation, assessment, and the treatment plan, as you have stated, is there any point in time this would have been self-inflicted?
No.
Okay. Moving on beyond that, were any of them? So let me take a step back. Were there any marks around his neck?
When you say marks, what do you mean by marks? Just the red
any
mark.
any visible indentations, any sort of material that was left over from an object, any specific markings?
No.
Okay. So just for clarity, this was not performed like by a belt or a chain or tie or anything.
No.
Okay. Just one moment, Your Honor. Let me confer with my assistant counsel. No further questions on direct, Your Honor.
All right. Any cross?
Yes. Hello, Dr. Watson. How are you doing today?
I'm doing good, Grayson. How are you?
I'm okay. Right. So, you said there was something that stopped his body from, I'm assuming, and I don't want to speak for you, processing oxygen. Is that correct?
From like receiving oxygen, yes.
From receiving oxygen. Okay. You also stated there is no way for this to have been self-inflicted. How did you come to that determination?
Your Honor, I'm going to object to weird.
How was that? What? I thought, Your Honor, I thought this was a serious court case.
Your Honor, you know what I mean by the objection.
No, she doesn't. Nobody knows what the fuck you mean by that. Shut the fuck up.
Your
What
Honor,
are you talking about?
Your Honor,
Idiot.
Can we, Your Honor, there's personal jabs and outbursts by the defendant.
Can I have counsel approach the bench, please, for a sidebar?
Sure.
Can you identify yourself, please?
It's Murphy, bro.
Oh, sorry. You're looking a little different there, Murph.
Oh, better?
No.
Cigarette doesn't work? Oh, man.
I think she's kink shaming, saying
Do I need to
choking
elaborate,
yourself
Your
is
Honor?
weird. But kink shaming shouldn't be done.
I mean, who hasn't choked himself, right?
It's my clear.
Your Honor, can we please stay professional in this? Your Honor, can I please have counsel direct everything to the bench, please? Your Honor, that other person is just standing here. We have someone that's not counsel literally standing here after you directed them not to be here, Your Honor.
Oh, I thought we cleared that up. Jesus.
Thank you, Your Honor. Apologies to the counsel.
I don't know. They're trying to kick me off the case.
Imperative that this stuff is
after like an hour and a half.
kept as tight as possible.
Yes. I think it's fine. Just to clarify, I don't think it's the absence of any particular other cause. I think it's this particular cause, and we probably shouldn't delve too deep into exactly what the determination was to come to that. It's a little on the nose.
cool? Can I just say that outwards? Can we just fucking stop talking about it? Is that cool? Okay, Blunt, can you handle this?
I think there's no objection at all to going down the road of whether other objects were used by a perpetrator. I think Marshal Sparks has very clearly identified the hot button issue here.
You know, like,
There's no objection
fine.
from the
Yes,
state
of
on
course
that
you
front.
are. You want me to read it out to you? No, okay.
All right, sorry about that delay. So Grayson, we were on cross if you would like to continue.
Okay, Dr. Watson. Hi. I'm sorry that got a little hot. Let's what I'm going to do is I'm going to withdraw that question. I'm going to ask my second question, okay?
Okay.
Okay. Dr. Watson, you stated under oath here today that it wasn't possible for any items to have been used to like cause these injuries. What methodology did you use to get to that conclusion?
Sorry, could you say it again for me? Apologies for that.
Okay. Dr. Watson, you stated today that in your expert opinion, there was no way that any items or objects could have caused the injuries that EMS Bowler had received that day. I'm asking, what methodology did you use to come to that conclusion?
Carrie, do you need the question repeated?
No, sorry. Give me.
I should not be able to hear anyone snoring up here.
And stop that.
From the markings, the mark that was like across his neck, there was no signs of like indentations or anything like that to show it was done by, say, something else, like an object or something.
So in your expert opinion, it couldn't have been a rope?
Yeah, no rope.
It couldn't have been a belt.
No.
What about a blunt object like, I don't know, police baton?
Dr. Perry, do you need the last question repeated?
Yeah. And then just give me a couple seconds after that.
Did you hear the word dick too? To throw you off?
It's not good. You just repeat the question. Sorry.
Could it have been a blunt object like a police baton?
At what point do we just say objection not answering?
That one I don't actually know.
Okay. Dr. Watson, you're stating to me an object could have been used? It's possible?
Misstatement of testimony. Counsel's testifying, putting words.
Can you hear me, Dr. Watson?
Your Honor, I'm going to object to counsel's testifying.
Your Honor, I'm leading and I'm allowed to lead. This is cross-examination.
All right. So the objection's overruled. Counsel isn't testifying. Perry, if you could please answer the question that was asked. Do you need it repeated?
Perry, in reference to your last answer to me, you indicated it was a possibility it could have been a blunt object. Thus, I'm asking you to elaborate on your previous statements to Councillor Sparks, where you stated that it couldn't have been a foreign object. So I'm giving you an opportunity to elaborate. Are you stating it is possible? I'm not asking probable, I'm just saying possible. It could have been a foreign object.
Due to the red markings and stuff, because they have not developed fully, that is a possibility that it could have been a blunt.
Thank you, Your Honor. That's all I need. No further questions.
15 minutes finish me? Okay.
All right. Marshal Sparks, Marshal Blunt, any redirect for this witness?
Defense count. Never mind, Your Honor. Hold on just a second.
What's it?
There's some icky territory that I just don't want to get into here.
I'm going to be honest, that doesn't really prove anything. Blunt object choking is the same thing.
Dr. Watson.
It's just weird.
Are you okay for me to continue
I
the
don't
line
agree
of
with that. It's
questioning with you,
weird.
Doctor?
I don't agree with that at all.
Yep.
Okay. You stated in your cross-examination with defense that due to the nature of the injuries, how recent were those injuries at your time of evaluation?
They were fairly recent due to the freshness of the marks, and no bruising had been present at that time.
So he essentially came to you immediately.
Objection. Counsel is testifying.
Rebuttal.
Sure. I'm not providing any new information. I'm not particularly reading anything off of anywhere. I'm not providing testimony. I'm asking for a clarifying question concerning the timeline that she has already provided.
I can be specific.
What?
Okay.
What in
About-
specifics?
Okay, the statement of immediacy indicates something, right? And it actually, what it's indicating is something that was not established with testimony from prior witnesses.
Your Honor,
Directly,
rebuttal. Okay.
Mr. Bowler stated that there was time in between the examination and when the injury occurred, allegedly. Marshal Sparks is now changing that timeline again for this witness. She's testifying.
Right. Marshal Sparks, would you like to rephrase that question?
Is that in order?
Please.
Okay, sure. You stated they were recent. How recent?
From person to person, it differs, so I wouldn't be able to determine how recent it was. It could have
All right.
been a couple minutes. It could have been 5 minutes. Who knows?
But it wasn't a long time.
Objection. Counsel is testifying again.
I'm going to overrule that objection. Counsel was asking a clarifying question. If we could please continue with our next question, if there's any further.
What do you have on record, Your Honor, for the answer to that question?
Just a quick no.
And my question was, it wasn't a long time. Is that what you have on record, Your Honor?
Yes, not a long time, and then the answer was no.
Okay. Clarifying question on top of that clarifying question, Dr. Watson. So it was a short time.
Yes.
No further questions on redirect.
All right. Is this witness being marked for recall by the defense?
One moment, Your Honor. Your Honor, we're not going to recall the witness. We are happy with the testimony we got.
All right. Dr. Perry, thank you so much for your testimony. You may step down. You're no longer under oath.
Thank you, Dr. Perry. I appreciate your time here today.
Thank you, Dr. Perry.
All right. Are there any further witnesses for the prosecution?
No, Your Honor. Would you like evidence highlight now prior to us resting, or would you like that in closing?
Whatever your preference is. If you'd rather have it during closing, you may. If you'd rather have it now, you may.
We'll mix it in with closing, Your Honor, on this issue.
Affirm.
And if you need a copy of my closing, I'll have it written and send it to you.
All right. Defense, if you have any witnesses you'd like to call.
Your Honor, the defense isn't going to call any witnesses here today. We are happy to get some kind of time to prepare closings and
right.
evidence assessment.
How long are both sides looking to have to finish up their closings and evidence highlights?
Yeah, Your Honor, we could probably take 10, 15, and then
We're
request
happy with
further
10,
recess
15?
after that.
let's call us back at 5 minutes till 5 then.
Okay.
Copy.
All
Right
right.
here, Your Honor.
Court is in recess for y'all to work on closings. I'll court back into session. It is 4:57 p.m. Eastern. If the people would like to move forward with their closing and evidence highlights.
Your Honor, we're providing evidence highlighting in our closing.
Affirm.
Whenever you're ready, Your Honor.
Hold on, that's kind of like a wiggle around so that we can't contest anything that they're saying. I don't know how I feel about that.
All right. If you would like to begin.
Sure. Just a moment, Your Honor. I dropped my notes. Give me a sec. Thank you, the good people of the court, Your Honor, and all parties involved with today's proceedings. Your Honor, I'm going to build this timeline of this horrific story and of police violence against our medical services. On or around January 2nd, a critical call came through that required emergency medical attention. That's directly supported by breakaway statement in the People's C and the incident in the People's B. We have breakaway statement in the People's C corroborating the initial incident of the timeline. Based on all this evidence and testimony, we have then Kyle Pred moving to the ICU and attempting to speak to EMT Bowler. Bowler then moves away from having to attend to the emergency room to injured individuals corroborated as it's stated in the People's A and Senior Officer Dark's deposition. Senior Officer observes Mr. Pred having his gun out and threatening with extreme violence and aggression, and I quote, to blow the hinges off the door. This is corroborated by Mr. Pred's own statement in the People's A. Statement,
Yeah,
with
that's not right.
consideration to the People's J, the defendant had the opportunity to clarify and add his own statement. Fortunately, with consideration to Senior Dark's testimony, Senior Officer Dark's testimony, that moment was subsided. Mr. Pred then put away his gun and shortly awaited a conversation with EMT Bowler. This is, Your Honor, where we pray to the court to consider a reasonable person standard. For the audience in the court, the reasonable person standard is as such. If given the same facts and circumstances, if given the environment, would the average reasonable person from that geosocial economic location act within the same accordance? Would a reasonable person then take the following actions? We have the victim's statement, his testimony, his interview, and Kyle Pred's own statement testimony. It was just them. It was them in the ICU waiting room. Due to patient privacy, we don't have any cameras or audio in that waiting room. All we have is two sworn statements. But wait, Your Honor, there's more. But I'll go back to the timeline, just to touch on that. What we know for sure is that a conversation occurred. Mr. Pred entered the ICU to speak to Bill Mays. We have in Senior Officer Dark's testimony and Marshal Ruth's testimony that there were no other individuals in the ICU waiting room or the ICU with Kyle Pred or Bill Mays. We have the victim's testimony, statement, and Mr. Pred's statement in the People's A that there was no one else in that room. This, without a question, is when the horrific act occurred. In the victim's testimony and his sworn statement and the written statement, all corroborated with the medical report in the People's A, show the truth. Kyle Pred exclaimed, "I am the chief of police." According to Senior Dark's testimony and Marshal Ruth's testimony, the victim's testimony, and all statements gathered, there were no clear indications, markings, vests, badges, or anything to determine that Mr. Pred was law enforcement. Instead, he utilized his station, declared who he was, and demanded to enter a secure facility. In his own statement, he stated he couldn't enter without the EMT's assistance. He gripped the victim's throat, exclaiming his violent intentions to stab the victim if he couldn't enter. And of course, the victim had no choice but by force and threat of extreme violence to let Mr. Pred enter the ICU. But here, Your Honor, by the defense's own admission and their own evidence in defendants A and B, there was a relationship between Kyle Pred and Bill Mays. Now, the nature of that conversation or relationship is simply hearsay. We can't guess at it, right? We can take the information that was gathered in the sub-reports and discussion with the EMS, Marshall Ruth's testimony, and sub-reports and in the People's A, and conclude that law enforcement acted within the best interest and course given that information. Once again, upon asking for clarity, according to the People's J, Mr. Pred refused. So what are we to conclude here? The defense is attempting to nitpick and point out what they consider, and I quote, disgusting inconsistencies with the victim's testimony. But in reality, Your Honor, an attempt that they have to point out the timeline in those crucial few seconds is irrelevant to the nature of the charges. The nature of Mr. Pred's identification happened at some point during the assault. Reasonably, does it actually matter if he said it before he battered Mr. Bowler, during the battery, during the threats of violence, during the actions of violence, or after the battery? Simply put, Your Honor, it does not matter. All other portions of the timeline are consistent. All other portions of this are of the statement, and the nitpick for this tiny little bit of information does not matter. There was information given on both sides. Mr. Pred was given information by Mr. Mays to see him. If not directly, but indirectly and implied based on the defendants A and B. And we can conclude, based on the defendants A and B, it was possible that Mr. Mays would have allowed Mr. Pred to enter the ICU and see him in a consensual capacity. But that's not what we have here, Your Honor. That's not what happened. A reasonable person seeing a concerned friend would give that information to a medical professional. A reasonable person would request that someone speak to the victim in the ICU or allow the medical professional in this case to speak to the victim, to speak to the injured party. Emergency contacts and requests in protective custody is not rock solid, it's always fluid. And if someone is hurt, Your Honor, they deserve to see people that they care about. They deserve to see law enforcement. They deserve to see people that they request. But that is not what happened here. What we do know, irrefutably, is that Mr. Pred did not provide that information. He did not let the victim speak to the ICU patient, Bill Mays. He did not provide any clarification. Instead, unlike what a reasonable person would do, he violently attacked EMS with the same veracity and aggression that has been shown in numerous statements per Senior Officer Dark's own testimony, the statement in the People's A, and the People's C for breakaway statement. This aggression is directly implied and also confirmed with numerous bits of direct eyewitness testimony. This is a violent action that is directly reflective of immediate medical attention requested by Dr. Perry Watson. This could not be done in any other capacity. Whether it was done by Mr. Pred's hands, he had something in his hands, and attack does not matter. Dr. Watson even confirmed it could have been up to 5 minutes. This in of itself confirms the veracity of the timeline given by each and every witness and each and every testimony and the medical report presented. It was the victim being battered and life threatened by the defendant. Your Honor, we ask you to consider all of these facts. The defense is going to say that there's doubts and philosophical thought on a quote-unquote a friend in distress for another friend. Why not discuss that then? Why give a separate statement? Why not provide an affirmative defense in any sort of capacity before charges were even pressed? A good person, a reasonable person, even an average person would ensure that their story is heard, that they would confirm they acted reasonably, attempting to speak to someone that they cared about. But that's not what happened here. Mr. Pred had the ability to provide that information to enter a secured medical facility, but he did not do that. Instead, he acted unreasonably. So we ask Your Honor, what doubt is there? There isn't. We assert that there was no room for actual real doubt here. There were two people in the room, injuries sustained, an immediate call for assistance, an immediate reaction, an immediate clear-cut timeline. That timeline is clear, it's concise. It's not like some magic alien popped up. This isn't some guess. We ask you to determine reasonality. Even If there are shadows or hints or any doubt portrayed by the defense to exceptionally nitpick different portions that led to that should lead to an actual reasonable conclusion, there's no one else that could have done this. It was just Mr. Pred and his wanton acts of violence. Your ruling on this court will be heavy, Your Honor. The people know this. It's a burden that you are tasked with, and it's not an easy one. I mean, no, this does not hold a light request. This ruling will have ripple effects that will cascade into the San Andreas Medical Group and affirm the line that should be drawn. Absence of this line will have dire ramifications. Our sentencing recommendation, Your Honor, is direct legal challenge to the current punitive and phrasing of the punishment for corruption. It is the sole basis of this challenge. No other reason. Corruption at this point is simply a pause without showing good, true faith and actions to change oneself to not act unreasonably within the government. Being part of the government, being the chief of police and the law enforcement officer, EMS, a judge, a lawyer, comes with responsibilities. So we challenge that particular clause and penal code. Other than that, we ask you to consider the statutory requirements and maximum as determined by the penal code. Nothing more. Even without all that, Your Honor, we offer this prayer. We pray to the court today to swing the sword of justice and strike down those who only work for the good people. Strike down those who would work against the good people. Defend the good people. They don't deserve the consequence for attempting to help, for attempting to heal. We ask you to protect the innocent, Your Honor, and find Mr. Pred guilty of his crimes. Thank you.
All right. Defense, would you like to highlight your evidence in line before or after your closing?
In line at the same time.
All right. I am ready whenever y'all are.
Okay. Your Honor, ladies and gentlemen of the court, non-binary people of the court. The prosecution states that we need to offer an affirmative defense. Grotesque. There is a presumption of innocence, legislatively demanded. My client is innocent until proven guilty. That is the standard. My client does not need to prove anything here today. I threw down the gauntlet in my opening to the prosecution, and I asked them, prove it, bro. And they failed. Today, the question isn't, do you think Chief Pred did it? The question isn't, is it possible he did it? The question isn't, why would Jimmy Bowler lie? With the presumption of innocence, the question is, did the prosecution today prove that Kyle Pred did it beyond all reasonable doubt? Because Kyle Pred, as he sits there in that horrible white suit, is innocent until proven guilty. All of those questions left unanswered are on a failed prosecution to have proven. Unsure as to why, unsure as to when, unsure as to how. Failed prosecution. All of it equates to doubt. You must enter deliberation, Your Honor, with the presumption of Kyle Pred's innocence. The prosecution cannot have overcome that. There are far too many unanswered questions, far too much doubt for any of the charges here to stick. I'm not going to repeat my opening. I'm going to highlight evidence and talk about what it means. On the 2nd of January, as shown in Defense A and Defense B, Kyle Pred was requested by Bill Mays to meet him at the hospital. He was called repeatedly and text clear request. Kyle Pred, on duty as a sworn LEO, as stated by Richard Dark in his deposition and reflected in report 38901, goes to see Bill Mays. Was this exigent circumstances? We don't know because Bill Mays wasn't called as a witness by the prosecution. They need to prove Mr. Pred's motive. They need to prove that he was there outside of his lawful duties, considering they are attempting to prove felony trespassing. They skipped all this. They didn't attempt to prove anything because the answers wouldn't fit a preconceived narrative. They didn't seek Mr. Pred's phone records, despite him offering an alibi in report 38901. Kyle Pred told them why he was there. The chief of police told them why he was there, and they didn't check. We provided proof. We've proven why he was there. That's not just reasonable doubt, Your Honor. That destroys the whole house of cards. Brooke Ruth, under oath, when deposed, stated there was a request over 311s from EMS requesting immediate backup at the hospital because he was held up by Kyle Pred. She felt no doubt. She went to the hospital assuming the allegation was correct. The investigation continued in this vein with a presumption of guilt. This was a pattern. It started the day before in report 38676, the Bill Mays ICO statement. Mays made an allegation. Ruth believed it. Presumed guilt. We've proven Bill Mays is a liar. We've proven he asked Pred to go meet him. We've proven that Marshall Ruth was fooled by Bill Mays. She really mazed it up, Your Honor, believing accusations without proof, only believing the testimony that fits the narrative that they wanted to believe. We call that confirmation bias. Every officer, Dark, Ruth, and Breakaway, who dealt with Pred and give testimony within the reports that when gave testimony in the reports that when asked to do something, Pred complied. He's Kyle Pred. He is an arsehole. But no officer offered any testimony that he acted criminally or outside of his lawful mandate as the on-duty chief of police on the 2nd of January. He complied with every lawful order given, both by Richard Dark and Brooke Ruth. The prosecution's alleged motive is gone. We know why he was there. He was requested to be there. Bill Mays was never under any threat. Why would Bill Mays request an active threat to go visit him? Did Pred have any means or opportunity to assault Jimmy Bowler? Other officers left him alone with him because they saw no threat from Pred towards anyone. We don't have any testimony from anyone outside of the alleged victim to that. Kyle Pred was not questioned outside of the statements he offered the day of. No investigation into his motives, his alibi occurred because the prosecution didn't want to hear it. They didn't want conflicting testimony from their given narrative. 2 people were in a room. Investigate both parts. We have the word of one person against another, then dubious accusations and inferences from a prosecution that has shown a commitment to a narrative beyond a good faith investigation as to what actually occurred. Jimmy Bowler repeatedly today, between his on-record statements contained within report 38901 and within the testimony given today, gave conflicting statements and timelines. The causal chain required to establish that Pred had the means, motive, and opportunity to be held criminally culpable for these charges was broken several times. The witness was unreliable. Now, whether that's because he lied or because he sustained an injury that caused him to be unreliable is irrelevant. It's doubt. Jimmy Bowler gave us doubt. When did Kyle Pred identify himself to the EMS? Before or after the alleged assault? We don't know. Did Kyle Pred identify himself as the chief of police? Did Jimmy Bowler then, denying what Kyle Pred asked him to do after identifying as chief of police, attribute himself to a charge of, I don't know, failing to follow a lawful order? I don't know. None of this was investigated, right? We don't know. We can't know. They failed to prove anything. Jimmy Bowler never directly identified Kyle Pred. He only ever stated someone who identified themselves as Kyle Pred might have done something to him. Even here in the courtroom, Jimmy Bowler had the opportunity to point out the alleged person who attacked him. Did not happen. Never happened. Never actively identified Kyle Pred. Just said somebody who said he was Kyle Pred did something. The investigators asking Pred further questions, requesting his phone records via subpoena, or even asking Pred for consent to have his records would have cleared up most of this. But none of that happened. That provides doubt that any of the lines of investigation simply were not followed up because of this inherent presumption of guilt. One person says something, one person says someone said something. They deny it. Inherently, there's reasonable doubt left. This can't be the evidential burden for prosecution. One person claims someone assaults them. There are no witnesses, no hard forensic evidence, only inference and innuendo. Everyone with any kind of bruise or injury is now a justice hand grenade ready to maliciously target personal enemies, if that is the standard. Dr. Perry Watson was unsure as to how the injury was sustained. She cannot confirm the marks were made by someone's hands. It might have been caused by a foreign object. It might have been caused by an accident. It might have been caused by anything. There's no assertion at all that Kyle Pred specifically caused any injuries. There's no corroborative evidence that Kyle Pred was involved at all. Just innuendo. We are left with the mountains of doubt. The medical report is vague. There's red marks. Nothing insinuating or proving that an assault occurred. None of this is beyond a reasonable doubt, but then again, none of this is more likely than not. My client was always willing to aid this investigation to prove his innocence. They never engaged with him. To the San Andreas State Marshals, he was guilty for being Kyle Pred. But we don't convict people for being belligerent arseholes. We don't convict people based on accusations. We don't convict people based on innuendo and inference. We don't convict today, Your Honor. The prosecution has failed to prove their case. We were left here today with more than reasonable doubt. We, the defense, without needing to, have proved more than the prosecution has today. We've given you reasonable doubt and doubt regarding the intentions behind this prosecution. The dire ramifications that Marshal Sparks and the prosecution offers about EMS and how they will feel if the prosecution fails is a motive manipulation done in bad faith because of your personal background. Write down this bad faith argument and assess the doubt. It is better that 10 guilty men walk free than that one innocent man is condemned to jail unjustly. That is the absolute standard of a justice system. No other standard. No standard about affirmative defenses. The disgusting nature of this prosecution by the marshals must set the standard that this is not enough for prosecution in San Andreas. San Andreas is a place of justice. I have worked my entire life to make it that way. I will not have my life's work sullied by such frivolous and baseless accusations. Thank you, Your Honor.
All right. So with that, there is a good amount that has been raised both in testimony as well as evidence highlighted to go over. I'm going to start my deliberations. I should have a verdict by 6:30. I will make a state announcement alerting everyone with 15 minutes notice before I reconvene in the courtroom.
Thank you, Your Honor.
All right.
Absolutely sorry. I'm going to go
Thank
ahead
you.
and call court back into session as both sides are here. It is 6:05 p.m. Eastern, Monday, January 2nd, 2026. And we're here for the verdict in the People versus Kyle Pred. The court has finished its review of the evidence highlighted, the testimony given, both the direct testimony today as well as the testimony from the depositions over the weekend. Both the charges and the requested sentencing and injunctive relief were all carefully considered and compared with the evidence and testimony. For the charge of corruption, the court finds Defendant Pred not guilty. There was testimony given that there was definitely attempted corruption, but the defendant declaring he was the chief of police and demanding entrance to the secured ICU area of CMC was not how he gained access to the secure wing. For the charge of extortion, the court finds Defendant Pred not guilty. For this charge, while there was evidence given that Defendant Pred compelled EMT Bowler to open the doors to the ICU, the court finds that the act of unlocking the door under coercion does not rise to the level of an official act completed under duress. For the charge of criminal threats, the court finds Defendant Pred guilty. Testimony from EMT Bowler stated that he was threatened with a pin stabbed into his neck, and as a result, he was in fear for his life. For the charge of unlawful imprisonment, the court finds Defendant Pred guilty. Again, testimony from EMT Bowler stated that he was held against his will and detained by Defendant Pred. For the charge of felony trespassing, the court finds Defendant Pred guilty. Testimony and evidence has shown that the defendant knowingly entered and remained within a secure wing of CMC, which is explicitly listed as one of the locations this applies to. For the charge of battery of a government employee, for a reasonable person reviewing the evidence and testimonies provided, there are three options for what could have possibly occurred. The first is as the prosecution presented that Mr. Bowler was choked by the defendant. The next, as presented by the defense, was that Mr. Bowler did this to himself, or alternately, that it was an accident and Defendant Pred was not involved at all. Based on the testimonies given and the evidence highlighted, including the medical report and statements given by a recognized expert witness, the court finds Defendant Kyle Pred guilty of this charge. For the charge of felony authority, felony offenses, as the defendant has been found guilty of the charge of battery of a government employee and said offense occurred within a government facility, the court has found Defendant Pred guilty of this charge. For the recommended sentencing, the court is denying the people's recommendation and instead going with the standard times and fines listed for each, which totals 87 months and $13,280 in fines. There will be no injunctive relief granted at this time. That is the order of the court.
How can I be found guilty with one person saying I fucking did something when I said I didn't do it?
If you could raise your hands, Mr. Pred.
I ain't raising shit. Don't you fucking touch me.
Please turn
This
around.
is the
This
biggest
my last
piece of shit
request.
I've ever seen. What are you gonna do if I don't? Huh? What you gonna
I'm
do?
placing cuffs on you.
Hey, go for it. Let's see what happens.
McAllister, can you place cuffs on him, please?
Hey, get the appeal up. Get the fucking appeal up.
The appeal.
How
I
the
need every-
fuck
I need
do
all
you
law
find
enforcement
this as the
to step
ruling?
away
Step away. Step away.
now.
Step away.
That is a lawful
Hey, don't
order.
you talk to Rhodes like that?
Please step away from Pred.
I'm sorry, we
Yeah.
can't see. We
What the
can't
hell
recognize
is
you.
it?
We can't recognize you.
I know, just I can't. Yeah.
Hey, get the goddamn appeal up. This is the biggest travesty I've ever seen.
Oh, there we are.
You have the right to remain silent. Anything you say can will be against you in a court of law. You have a right to an attorney.
Jesus fucking
If you cannot provide
Christ.
one. Sorry, you have.
Get the
You
fucking
cannot
appeal
afford
up.
one. One will be provided to you by the state free of charge. Should there be one available? Do you understand
Guys,
your rights,
get,
Mr.
get
Pred?
the appeal up. Get the
Do
appeal
you
up,
require an
boys.
attorney at this time, Mr. Pred?
I ain't talking. Send me
Understood. I'll be searching you at this
Get
time.
the
Is there anything
appeal
that will
up, boys.
invoke or broad me?
up. Absolutely nothing on me.
Perfect. We're gonna go downstairs and we'll grab your possessions and then we'll take you to the marshal's
God,
office.
what the fuck is this? One person says I did something, a medical report where they say, hey, we don't really know how it happened. I didn't do the shit. I'm there on exigent fucking circumstances. Bill Mays said, hey, you're laughing for now. Wait till the fucking appeal. Jesus fucking Christ.
Oh,
I don't
Chief.
understand how you guys made policing this bad.
We got your back, Chief.
Wow.
Let me
That
go
was
rub the
hilarious.
arrow on his face.
I'm stuck.